Well, thank you. Thank you, Professor Chen, for this invitation to Hong Kong University. It's actually the first time I'm here, and I'm excited to get to know your students and colleagues, some of whom I've met and interacted before. My talk is today about automated private enforcement. And this is joint work with Jakob Merane, who just finished his PhD at ETH Zurich and who is in many ways the major intellectual force behind this project. What I'm planning on today is I want to first introduce you to the Google fonts dispute, which might seem like a niche topic to you unless you are interested in online privacy. But I then want to explain to you how this case offers a unique opportunity to study a very fundamental legal design question, namely the question of what the effect of providing an effective instrument for the private enforcement of small claims is. And I will then conclude that the automated enforcement using AI-powered enforcement bots, and I will explain what I mean by an enforcement bot, will create a major disruption to the legal system that goes far beyond the use case of online privacy. So let me first tell you about the Google fonts dispute. When you design a web page and you want to use text, you will need to define the style of the fonts that you use. So many web pages use Google Fonts, which is an online font database Google provides for free. And there are two ways to embed these fonts on your web page. You can choose static embedding or dynamic embedding. Static embedding involves a line of code that fetches the font style from the file that you self-host on your server after downloading it from the Google Fonts database. So for instance, here, this is the webpage of the German Law and Economics Association, and they actually use static embedding. We checked it. It's possible to check what web pages do. Then there's dynamic embedding, which equally involves a line of code. But here, the web page fetches the font style from the Google database each time a user visits the web page. And here you have the web page of the European Association of Law and Economics, which actually does it dynamically. Now, the problem is that dynamic embedding sends users' IP addresses to Google in the US. And so in January 2022, a court of first instance in Munich held that dynamic embedding violated the GDPR, which is basically the EU's online privacy directive. Now, if you take this German ruling seriously, depending on the country you're looking at, about 40 to 70% of websites were in violation of the GDPR at the time of the ruling. 40 to 70%. So how are these massive levels of non-compliance sustainable? Well, it's well known that public enforcement in this area is very weak. And this is despite high-profile cases and public pronouncements to the contrary. I mean, we sometimes hear the European Commission is pursuing, I don't know, Meta or Google or X for violations, but actually, if you look at their public enforcement of the GDPR, it's actually quite weak. Now, the party that brought the suit in Munich was actually a private citizen, and the court awarded him immaterial damages of 100 euros. So although the GDPR under Article 82 grants a private right of action, and although the European Court of Justice, unlike the US Supreme Court, I don't know whether you know these distinctions, but has rejected the notion that you need to establish that the harm you suffered exceeded some kind of seriousness thresholds to claim non-material damages. So in the EU, you don't have to have the seriousness threshold to have standing. You have to be a real stickler for privacy. to be motivated to bring a suit that probably takes 2 weeks of your time in order to get 100 euros of compensation. Now, imagine now an innovation. Imagine that you can develop what we call an enforcement bot. And that is an AI-powered algorithm that crawls the internet, flags web pages that are non-compliant, and then automatically sends out letters threatening the companies behind the web pages to file complaints in court unless the companies pay, say, 200 euros in compensation for the violation and cease to embed Google fonts dynamically. What you can see is that you can literally make tens of millions of euros employing such a strategy with this GDPR violation alone. And I can assure you that people in my team and in the team of colleagues actually have found many of these violations. I mean, I just want to highlight one of them, which was not done in my team, but which I think is quite fascinating. You often get, I don't know whether that's the case here in Hong Kong, but you often get these cookie warnings where you are asked whether you agree to have certain cookies on a web page, and you can say, yes, I agree, no, I don't agree. So what they did is they just programmed an app which they uploaded in the Apple App Store, and that actually allowed them to see the data flows between the service providers that try to provide the service of cookie compliance and the app. And they found that many apps don't ask this question, and if they ask the question, they ignore your answer. Basically, you say no, you don't want to be tracked by cookies, and they do it anyway, which is maybe more difficult to detect than what we have in the Google Fonts case, but I could go on and on with these violations. So you could actually use these enforcement bots, which are not difficult to build. I mean, they take a couple of weeks, sometimes only a week, sometimes 2 weeks or so to program. And you could, in theory, make millions going after companies. Okay, so this is not science fiction. This is actually something that's going on. I can show you. This is, for instance, the crawler that we've programmed that automatically registers you at certain web pages. And that's, for instance, one possibility that we have to check whether newsletter consents, whether you have given consent to newsletters and whether that's respected. So there are a couple of these enforcement bots that we've built. Now, what's interesting about the case, the Google Fonts case, is that a couple of entrepreneurial lawyers in Germany and in Austria actually saw this opportunity. And I should mention, as I said, that creating these enforcement bots is not difficult at all. And I've joked with colleagues some time ago that we could actually put a server down in the basement of ETH and maybe double our research budget. We've not done so for obvious kind of reputational reasons, but that's what these lawyers tried to do. Now, you could still say, well, you're trying to convince me that there is a way to boost compliance on online privacy rules, but fine, I don't care very much about privacy on the internet, and most people don't. Now, if this is what you think, and I'm sometimes kind of like that, I will tell you that those results should still interest you because they make first inroads into answering a much more fundamental question in law, namely, what is the potential for the automated private enforcement of small claims? Or if you wanted to make the question even bigger, what's the effect of unleashing entrepreneurial lawyers to enforce small claims? Now, automated private enforcement is just one way how this can be done. And the traditional way is class action. And we all know that in the US, class action coupled with contingency fees provides extremely lucrative opportunities for lawyers to pursue small claims. And in Europe, such instruments are mostly missing, and this shows in the amounts victims recover in mass litigation cases. So for instance, you've probably heard about the Volkswagen diesel scandal. In the US, there was a very quick settlement already in 2016 for 14.7 billion. And in Germany, where arguably there were much more of these diesel cars, there were settlements of 830 million in 2020. And these huge settlements in the US were of course driven by lawyers threatening class action. Now, automated private enforcement and class action, that's my argument, are largely substitutes. One is about economies of scale to deal with the problem of bringing, of basically distributing the cost, the fixed cost of bringing a suit across many shoulders. And the other one is about driving the marginal cost of bringing a suit to close to zero. Now, the basic legal design question is, do we want a legal system with an effective instrument to bring small claims? And one of the major factors, I'm not going to answer this question yet, but I think one of the major factors in determining whether we want such a system is to answer the question, what is the effect on compliance of having such a system? Now, this is a hard question to answer because to answer this question, we want to ideally compare the current US system, which in reality has class action, with a hypothetical US system that doesn't have class action. Or we would like to compare the current European system that in reality does not have effective instruments for enforcing small claims with a hypothetical European system in which such a system or such instruments exist. Now, you see what I'm getting at. The Google Fonts dispute offers a unique opportunity to study this otherwise elusive question. This is because we have a setting in which we can go to the so-called HTTP archive, which records web pages over time. So for those of you who are not familiar with the HTTP archive, you can imagine this as something very similar to, let's say, records of historical stock prices in finance, where we can observe the price at a given point in time. And here we can observe, we basically have an archive that takes snapshots of web pages, all the web pages on the web every month. And so you can go back and observe whether web pages embedded Google Fonts dynamically or statically. And that means we can see what happens to compliance after the German court ruling is handed down. And then we can see what happens to compliance in Austria when the Austrian lawyer built an automated violation detection claim generation software and started this letter writing campaign. And as this only happened in Austria, we have the opportunity to run both an event study and a difference analysis to get at the marginal compliance effect generated by the effective private enforcement of small claims. So if you don't care about privacy on the internet, think about our study like most US college students think about Florida. They don't care about Florida, they care about a cheap way to go to the beach. Yeah? So we care about a cheap way to get to an interesting question, and it happens to be that the Google Fonts case offers us this opportunity. I should also mention that this didn't only happen in Germany, in Austria, it also happened in Germany, but we don't use Germany for the identification of the effect because there were multiple waves of letter writing campaigns by different lawyers in Germany, and we were not able to really easily disentangle when these lawyers wrote or started their letter writing campaign. So for Austria, there was only one and was easily identifiable for us. The problem is also that these lawyers, for reasons that I can also tell you later, are very much in trouble right now. They are in trouble because they have run afoul a couple of legal rules. I also think it's a nice sociological case study of how the legal system reacts to disruptive innovation. So they are in a lot of trouble, and in a lot of court cases, we think we think they could have done it differently and would not have run afoul these laws. We can talk about this later, but this also means that these lawyers, who you would imagine would be proud of what they've done and would be very willing to share details with us, they are involved in litigation. And so you can't really go to them and ask them about what you did, because they will probably even disclaim that they used AI to find out what these offenders were, because this is currently subject to lawsuits. So we used Austria because we knew there was only one campaign. We could, in theory, use Germany, but we would need to know more details about when these waves happened and what regional targets that they had to really do this. So the analysis that I'm going to present to you today is based on the Austrian experience. Okay, so what is the data set? After I've now given you the big picture, let's now go into the weeds to convince you that I can indeed demonstrate my claim to you that we can get massive compliance through automated private enforcement. So we use the Google Chrome user experience report to obtain a list of the top 100,000 websites across 32 European countries. That way we get 2.6 million websites. Some smaller countries don't have 100,000 websites, so that's why we have 2.6 million. We then collect the data about the HTTP requests made to the Google Fonts API through the HTTP archive. And then this gives us in total 68.7 million observations, as we collect 26 data points, Google Fonts usage, yes, no, for all 2.6 million websites in our example. Sorry, I should have said not Google Fonts usage, but Google dynamic embedding, or yes or no. And we get this for 2.6 million websites in our sample. And this is basically 13 months prior to the letter writing campaign and the 13 months after. As some web pages are the same in more than one country, and some web pages were not archived each month during the entire observation period, we get 50.5 million unique observations. Now we assign a country to each. We assign a country to each website based on its country top level domain, and then we match the data set with other firm level data sets based on the URLs. I don't want to spend too much time on the details on which data sets we use and why, but details are described in the technical appendices of the paper. So you see we had a couple of robustness check to be sure that any of our results would not be driven by the particular data set that we use. So sometimes, you can use the Wayback Machine, or you can use the HTTP archive. We use the HTTP archives because it's more representative for Europe, but if we use the Wayback Machine, nothing in our results changes. So we've done our homework to check whether this is robust to the choice of other defendable data sets. Now, let me give you the descriptive statistic. So this paper documents privacy violations, which in size and distribution are largely in line with the existing literature. So other studies have shown the incidence of privacy violations is high, between 40 and 70%, depending on the country. We also establish that more popular web pages and bigger companies are less likely to be in violation. That's also what most people thought to be true. This might, of course, be due to differences in legal expertise, available resources, and also expected enforcement. I told you that the regulators are often going after the bigger companies and not the smaller companies, although I should stress the law doesn't really differentiate between big and small companies. And then also the prevalence across industries is quite in line with prior findings. So, for instance, porn and finance, very compliant, media, not so much. The next graph descriptively shows you the entire story. Oh, here here you see the different sectors on this slide. Now, this graph now shows you the entire story descriptively. So you see 27 countries plus Germany and Austria, and so this would be the dark blue line would be Austria, and this is July 22, when the lawyer starts his letter. And here you have January 22 when the Munich court hands down the sentence. So you see there is nothing of a big decline here. We will analyze this, of course, as well. And for the German data, maybe there is a little bit of downward trend, but in Germany, we have over this whole period, we have these different letter writing. So you see everything is almost stable, but then you have this movement in Germany, where we had the letter writing campaigns, in Austria, and this was the event in Austria here, July 22. And then there's maybe another country where we have kind of a downward sloping compliance rate, and that is actually Italy. And the interesting thing about Italy is something that we only discovered after we've plotted those lines, is that there was a small NGO that also wrote letters to mostly public institutions and told them, you are not in compliance with the GDPR. Here's this ruling in Munich. Now, it would, of course, be tempting to say, oh, let's exploit this to see the difference of marginal compliance induced by private for-profit actors versus NGOs. But there were so many things that were different between this campaign between of the lawyers in Austria and of this NGO in Italy. So for instance, in Italy, it was just a notification. They never threatened any suit, whereas in Germany and in Austria, the lawyers, of course, threatened a suit and asked for a settlement payment. But this small decline in Italy is actually due probably to what this NGO did. There's also some indication, that there is a German-speaking part of Italy. It's basically southern Tyrol, and if you look at the impact of these campaigns on searches for Google fonts, you see that actually searches for the term Google fonts stays relatively flat in Italy, but increases much more in southern Tyrol. So there might also be some spillover effect from Austria to southern Tyrol. But basically, you see there's nothing happening but in these three countries, and what we are focusing on is the Austrian campaign. Okay, so let me now give you an explanation of our empirical analysis. Basically, what we are doing is we have a diff and diff analysis. You see here the baseline model. Y denotes the non-compliance rate in country I at month T. X1 indicates the group, whether you are in the treated or the untreated group. Basically, in our main analysis, Austria will be the treated group, and the rest of the 27 countries, with the exception of Luxembourg, Liechtenstein, Malta, and Germany, are the untreated group. So we excluded Luxembourg, Liechtenstein, Malta because there were just not enough web pages in those countries, and Germany because, of course, Germany was somewhat treated, but as I explained to you, we were not able to really identify these pre-lawsuit campaigns, which were staggered over a period of multiple months. But this is, in theory, something that we could or even should do, because in these types of studies, you would sometimes want to have more than one treated, or more than one treatment, but we look primarily, as I said, on Austria. So what you can then X2 indicates the time, whether you are in pre-treatment or post-treatment, and then we have the interaction term, which is group and time and country fixed effects. And you can then immediately see that for the difference in difference analysis, we are primarily interested in the coefficient beta 3, which is the coefficient of the interaction term. And we are interested in that because we want to see whether when moving from pre-treatment to post-treatment, the compliance rate in the treatment and the non-treatment group is affected differently. So basically, that's the idea of the difference in difference analysis. We want to see, oh, there's an event. And if we were only to see that in Austria it goes down, we would not causally identify the event as being, the event as being the cause for the decline, because it could be that there is some unobserved variable that triggers the decline. But if we then compare it to countries where the event did not happen and they stay flat, that is basically the idea of the difference in difference identification. Now, here are the results. If we look at only actually this is here, if we only look at the effect of the ruling in Munich, you see the effect is borderline significant for Austria. We have it here, which might seem surprising given the graph, but you see the effect is very, very small. And given that we have 50 million data points, it's not surprising that you get significance. Also, the pre-trend, the parallel trend assumption is violated and so on. So don't make anything out of this. You better look at effect sizes if you have so many, so much data. And what we see is that pre-law letter effect, pre-lawsuit letter effect is huge. We have roughly 23 percentage points reduction, and that is cutting basically non-compliance by half. Now, I also wanted to mention that, so this is actually the regression result here. What I also wanted to mention is that we did a lot of different robustness checks. We could go into them in the Q&A if there are people who are interested in the econometrics, but basically there's a very new test which is called the honest difference in difference approach, which uses some partial identification technique if there are small violations of the parallel trend assumption. We did this. We ran a couple of placebo tests. So I think we've done our homework on checking robustness. Then last point that I wanted to mention is that we were also interested in the channels of increased compliance. And so we conducted an additional survey to find out through which channels the increase in compliance was achieved. In our sample, there were about 8,000 non-compliant web pages, and roughly half of them changed their behavior and the other half did not. And so we send actually a survey to all of these 8,000 non-compliant web pages via email. Now, take everything I say with a grain of salt because we only had a 3% response rate. You see, by the way, the big advantage of going to the HTTP archive for our main results, because there we have 100% of the web pages. Here we have the big problem of what you always have when you send out surveys, that you only get 3% or 5% of people to reply to you, and you then wonder, of course, about selection effects. But I just wanted to briefly mention what we saw. 20% of the respondents indicated that they had received a pre-lawsuit letter, and that suggests that there was some degree of general deterrence here as well. So 40% of the respondents reported that they changed their behavior after reading media reports about this letter campaign, and 25% reported they were influenced by peer effects. So basically other people in friends talked about this letter campaign, and so they changed their behavior. Those who received a letter were 10 percentage points more likely to change their behavior than those who just heard about the potential violation through media coverage, but this is a small sample, so this was not significant. Also for the demographics, 50% of these firms were managed by a single person, only 11% had an IT department, and 31% outsourced their IT to some outside provider. Now, I mentioned to you that there were these very harsh reactions to this letter writing campaign in Austria and also in Germany. So the legal system's reaction was swift and harsh in both countries. The lawyers currently face multiple civil and criminal cases and the threat of being disbarred. Basically, the story was that what they did is they pretended that they represented a real client when actually just allegedly just the crawler went on the web pages. And so basically there's now a criminal suit that they committed fraud. But you could easily imagine, and we've built something like this, that you create a plugin where, let's say, individual users download this plugin from you, and then whenever they visit a web page, the plugin alerts them to the fact that there's a violation, then they can just press a button and refer it, let's say, to a lawyer. Then we wouldn't at all have this problem of fraud. So it's an easily solvable problem, which they have not really done because probably they didn't anticipate the legal system would react so aggressively. So we don't think that the fact that these lawyers are now in trouble means that basically the chapter of enforcement bots is closed. I think it's more this sociological phenomenon that something happens that everybody is very surprised by, and then there is severe reactions by the legal system. There's also in Germany, the courts have decided that this way of pursuing claims was an abuse of rights. But I think every student knows that if you use these types of doctrines, it shows that you're kind of helpless in finding better reasons. So this is what we currently observed on this front. Now, I want to also tell you that I think there are applications beyond online privacy. Online privacy is kind of a niche topic. So, for instance, you can use satellite imagery technologies, for example, to do real-time detection of environmental violations, such as illegal deforestation, unauthorized land changes, pollution incidents. There's a big paper on this. You can do drone monitoring that enhances enforcement capabilities against illegal logging, deforestation, also against traffic violations. And furthermore, there are platforms that leverage citizen participation, such as New York City's idling vehicle reporting initiative, where basically you have an app where you can report trucks or cars that leave their engine going while standing, which is now against the law, and you get a bounty or a small compensation for reporting this illegal activity. So the private citizens act as kind of private attorneys general that would reporting. And you could imagine that this could be applied to many violations using these techniques. Now, what are the implications? Given that the detected effect was huge and the required technology is readily available, it's useful to reflect on these implications. The most obvious effect that comes to mind is that automated private enforcement might create major disruptions. The point is that automated private enforcement does not require legislative action. It's just an entrepreneurial lawyer who wants to make a profit, who can pursue these strategies under existing laws, and therefore with the risk of an unmanaged disruption. So the advent of this entrepreneurial lawyer or an activist consumer protection agency aided by enforcement bots might pose a challenge and an opportunity for lawmakers who will have to carefully think about recalibrating legal rules. So, for instance, if a legislature thinks, oh, let's introduce class action in Europe, there will probably be lots of people who say, yeah, but maybe there's going to be over enforcement in certain areas, so maybe let's not do it. And you have all these discussions. Here, it might be largely unmanaged because with no change of laws, profit-seeking entrepreneurs could just and lawyers could just deploy these algorithms, and maybe some of the laws were not even done in a very deliberate manner. Maybe they are not very well calibrated, and so, for instance, lots of the uproar actually occurred because suddenly all these small businesses were targeted by these lawyers whom the regulator had never targeted, and so this was probably not what the legislature intended. But of course, the legislator could recalibrate the law and say these requirements only apply to companies above a certain size. And maybe that's the pressure that's going to be put on the legislator. So they need to, in some way, engineer the right level of enforcement. Then I think the advent of enforcement part also raises an interesting legal theory question. So far, the legislator could sometimes enact quite purist laws for expressive reasons, knowing that they are unlikely to be enforced. So for instance, you would say, let's have this very purist privacy regime to signal how much we care about human dignity and privacy, knowing that it's not going to be enforced. Now, given these enforcement bots, you lose this instrument, and using legislation just for expressive reasons might actually be a risky strategy. Now, besides these entrepreneurial lawyers, I already mentioned that enforcement bots could also be helpful for NGOs, but also for government enforcement. So we can imagine that agencies use those tools themselves to detect privacy or to follow up on companies to whom they have punished or whom they've ordered to do certain things. And then, currently the problem is that sometimes these companies say, yes, we agree, and then they don't change their behavior. Now, these enforcement bots could help to check on them. And we could develop such tools and rely on the private attorney general model, as I described before with this example of the idling vehicle laws in New York. Now, there's also, and that's the last point I want to make, an interesting research program or research question that arises. Many people, lay people, probably implicitly assume that the desirable level of enforcement of a law is 100%. Now, if you are an economist, you probably say, no, this is not correct, because that would actually be too costly to do. So basically, the argument currently is cost. But if you imagine that you can push the marginal cost of enforcement to zero, there's no, this traditional economic argument for not having 100% enforcement basically goes away. And so the question is, do we want to have 100% enforcement if there are no economic costs of doing so? And I think that raises this very interesting question whether there are other reasons why we might not want to have 100% enforcement. Maybe in some areas we want, but in others maybe we don't. You could imagine, for instance, that if you always get a little slap on your wrist for every little violation that you do, it might create, you might be a very anxious person, and maybe it involves, it will change your subjective feeling of freedom in a way that we don't want, maybe for deontological reasons because we think it is against human dignity, but also for instrumental reasons because it might actually hamper creativity and innovation if people always feel surveyed in this very intense manner. Yeah, so those are, this is maybe a last thought that I wanted to give you. So on this note, let me end, and thank you very much for your attention. I'm looking forward to the discussion.